So Joel, we've covered a lot of considerations here related to terminations and layoffs. I'm going to turn it over to you to walk us through the key takeaways that attendees should have on their radar.
Absolutely. So the first one is that employers should account for these added considerations we've been talking about when terminating or laying employees off during the pandemic. You need to do it carefully. And you need to be careful of all those added risks that we've been talking about, the reprisal and the human rights risks that you want to talk about, among many others. Now, in addition to that, employers should be assessing termination entitlements before letting people go. Employers should consider all those different entitlements that I spoke to pretty quickly earlier. Common law entitlements, contractual entitlements if there's a termination clause, statutory entitlements under provincial employment standards legislation. For unionized employees, any additional entitlements in collective agreements. All of those things need to be considered to understand what the true cost of letting an employee go would be. And specifically when it comes to the employment standards considerations, what employers need to be mindful of is generally they know about the regular notice or pay in lieu of notice obligations under the statutes. What fewer employees know about, because it doesn't come up as often, are the mass termination obligations that employers have as well. Now, most Canadian jurisdictions, just about every one in fact, provides for additional statutory notice if a certain significant number of employees are let go in a short period of time. So to use Ontario as an example, if at least 50 employees are let go within a 4-week period, they're going to be entitled to 8 weeks notice, no matter how long they've been employed. 8 weeks generally in Ontario is the maximum amount of notice for employees with 8 or more years of service. But in this case, it doesn't matter how long they've been working, they're going to get the 8 weeks if 50 are let go. That number goes up to 12 and then 16 with larger numbers of employees being let go in that 4-week period as well. Now, the third one that I want to speak about here is creating an effective termination and layoff and recall strategy. Employers should generally be transparent about the reason they're letting employees go right now. When the reason is business downturns, revenue reductions, and inability to keep all the staff on, employers should be transparent about that. That helps to protect employers' reputations, avoid some of these claims that we've been talking about for reprisal and human rights when employees don't believe that's what happened because that's what the employer is telling them. And it also helps to protect the reputation where, for example, if an employee feels like they were treated in bad faith or unfairly in being let go during the pandemic when they can't get another job, they're much more likely to feel like they were treated callously and go and speak to the media or post on Glassdoor or tell other people that this employer is unfair. And that's really bad for an employer's brand. So that's something to be mindful of. Now, additionally to that, in creating that termination strategy, employers should really think about the big picture cost. If the main driver for a termination or for a number of terminations right now is short and to a lesser extent medium-term cost cutting, employers should think not only about how much an employee costs on an ongoing basis, but also the termination entitlements. To use a really simple example, if there are 2 employees in a similar role and the employer decides they can only afford one of those, and one is shorter service and has a much lower salary, employers may want to keep that shorter service, lower salaried employee because of the ongoing cost savings. However, if the other employee is much more senior, has been working for many, many years for the employer, and especially if there's not a termination clause to limit the common law notice obligations, the employer may be looking at 6, 12, 18, 24 months of common law notice obligations to pay out. And that may be something the employer can't pay as well. So they should look at the big picture costs before making these types of decisions. And one more when it comes to creating these effective termination strategies is thinking about working notice. Employers tend to, in most cases, prefer not to provide working notice, which of course common law notice as well as statutory notice can be provided by allowing the employee to work out the notice period instead of giving them pay in lieu of it. Employers typically don't like to do that because there's concerns about employee morale, both that employee particularly, and also their impact on others' morale when they're upset about having been let go, and maybe even concerns that they'll sabotage the business because they're so upset. Those concerns are absolutely valid, and they're valid now as well, but they're in many cases going to be less of a concern because of the pandemic, because employees generally will understand a bit better when an employer clearly has a significant revenue reduction. They understand that something needs to be done, and so they may not take it quite as personally as they would otherwise. And if they're working from home, if the employee is at home working, they're going to likely have less of an impact on other employees' morale, as well as less of an opportunity to try to sabotage the business if they're the type of employee who might do that. Although in those cases, you may want to avoid the working notice nonetheless. Now, if you do use these working notice strategies right now, And if you're an employer that collects the Canada Emergency Wage Subsidy, again, 75% of employee wages until the end of August, if you remain eligible until that time, then something to think about is providing working notice, because then you can actually receive that wage subsidy to pay a bunch of the termination entitlements for the next 2 or 3 months if you remain eligible until the end of August. That's a really helpful tool, but employers should understand that if an employee is let go without notice, that wage subsidy cannot be used to help pay for the pay in lieu of notice the employee is entitled to. Now, the fourth one I want to speak about here is that employers should track layoff lengths closely. You want to talk about that. When the layoff period allowed under the employment standards legislation expires, the employee is going to have a deemed termination and be entitled to their termination entitlements. It's very unfortunate for employers when that happens without the employer even realizing or intending for it to happen. So pay attention, and if you don't want to let the employee go, make sure you call them back before that period expires. And also maintain communication with your employees during those layoffs. Maintaining that communication helps keep employees engaged throughout the layoff, understanding they're going to be returned, the employer is still thinking about them. And for those who decide to leave, it's going to let the employer know that that employee isn't coming back, and that may be one less person the employer has to worry about termination entitlements for if they can't call everyone who's been laid off back at the end of the layoffs. Now, the last one that I want to speak about here is that employers should document business changes that result in positions no longer being available, either temporarily in the case of layoffs or permanently in the case of terminations. You want to talk about those reprisal and human rights risks that exist there, and those are very significant, and we're actually already starting to see those claims from employees. Just earlier this week, one of our clients received a claim from an employee that they let go in the thick of the pandemic when they realized they had to let a number of employees go, and the employee is claiming they were reprised against in the termination because they were let go during the pandemic, and the employee claims it was a reprisal for the employee trying to assert their occupational health and safety rights. Now, the employee is actually arguing in their application that they were let go and they weren't laid off, and the fact that they were let go rather than just laid off temporarily is evidence itself of the reprisal. And so if employers can document the reasons they need to let employees go, lay them off, make sure that that's clear in writing at the time the decision is made, that's going to help defend against these types of claims of reprisal or human rights violations that are really not valid, but sometimes difficult to defend against nonetheless.